Hi everyone, my name is Jim Urell. I'm the CEO of Property Button. Hopefully you guys know us already. I guess you have because you've signed up to the seminar. We're here today to talk about GDPR and in particular GDPR's implications in the letting agency business. So who am I? As I said, I'm Jim Urell. What does Property Button do? So we build software for letting agents and estate agents, and that software is designed to organize the communication. So when we looked at the communication market, first of all, we saw that there were CRMs and other tools to manage the business processes and the data flows inside organizations. But we saw that communicating with third parties like utilities or insurance companies, banks, field workers like carpenters and plumbers, that just didn't work, and it was working over emails and SMSs and paper, and it was just super difficult to manage a consistent level quality of service. So we looked at that and went, we need to automate those business processes and data flows, and to be able to give our customers, letting agents and estate agents, a system that will allow them to deliver a consistent level of customer experience to their landlords, buyers and sellers and tenants, give them an audit trail for compliance, and give you a new revenue stream. So from the commission share that we pay on all services that are procured through the platform. So that's the vision for our business and kind of our genesis, our background. What we see in the letting agency business and the estate agency business, that the compliance burden is just increasing all the time. We see, obviously, GDPR that we're here to talk about today. Recently, there's been lots of press coverage about discrimination. You know, we saw HAP, the Housing Assistance Program, was in the news a short while ago. BER obviously has been around with us for nearly 10 years now. They're all renewing next year. Safety certs on boilers, red pressure zones, PRSA audits are increasing, particularly around the client account management. Energy regulation is just getting harder and harder, and data protection commissioner audits. So I've in the last week I've been to visit 3 significant customers of our business here, and all 3 of them have been audited within the last 6 months by the data protection commissioner. And in each case, the data protection commissioner has told them that they can't request or hold information on people requesting viewings of properties at all. They can only take their email address, and then they have to invite those people to viewings, which opens them up to all letting agents and estate agents up to all sorts of abuse. So we wanted to solve that. So what we've done with our software, and we'll show you this today, is we've designed it with GDPR compliance in front of mind. So it's designed to be GDPR compliant, that it manages the data protection requirements, and that it will meet the standards of a data protection commissioner audit, that it is aligned with the anti-discrimination regulation, and that it delivers the audit trail you guys need to keep your customers happy with respect to energy regulation and the BER service. So getting straight into GDPR, and hopefully I won't put any of you to sleep with this, because this stuff is very, very important, but it's quite detailed, and it can be a bit overwhelming, or at least I feel it can be at times. So GDPR stands for General Data Protection Regulation. It's effective from the 25th of May. There's been approximately a 1-year lead into that, and it's consolidating all of the individual data protection rules across all the EU countries. So it's an EU-wide piece of regulation. In terms of enforcement and audits, as I said, the Data Protection Commissioner has audited 3 of the customers I visited in the last while. Their budget was increased by 56% this year, and we're seeing increasing audit work from them. which means the enforcement of these regulations, it's going to be enforced a lot more than previous regulations that we saw, and we're already seeing that in the market. But we don't need to be too scared about GDPR, because we can boil it back into the key principles and the key reasons for lawful processing. So although it sounds super complicated, I think we can simplify this for ourselves, and just realize it's mainly about consent, like getting the right consent at the right time. And then after that, in terms of the letting agency business, after we've used the consent basis for lawful processing, to use the contract basis for lawful processing, then to hold information. And we'll go through that now and try and simplify this process down. So in terms of GDPR, there are a number of articles in it. It's really very much legalese. But the first thing that you should do is identify whether you're a data processor or a data controller, because there's a different set of requirements for each. There's a simple test really for whether you're a processor or a controller, and the way we look at that is if you can delete the data that someone has sent to you or that your staff have given to you, then you're a data controller. Now, lots of people can have different opinions on that, but I always feel it's best to try and simplify that down. So if you can answer for yourself, can you delete the data that's being provided to you? Like, is it within the control of you and your business to do that? Therefore, you're a controller. And when we looked at that, we assumed then that, you know, pretty much every estate agency and letting agency is a data controller. And on that basis, we looked at then Article 5, which is the key principles, and apply those to letting agencies. And that's what we've done here in this presentation today. So there are 6 legal bases for processing, and we're going to talk about those in a minute. And that's one of the key principles here. The next key principle is about the collection of data, that it just needs to be done in a really clear way. So we've all seen where we signed up for services, and we won't mention the name of the big tech giants, but you probably all know what I'm talking about, the 42 pages of really small text terms and conditions that you sign up to. You know, that's old hat now. You can't do that anymore. The reason, also, if those companies in the past, they've just collected absolutely tons of data, and that data, a lot of it hasn't been appropriate to actually what they're supposed to be doing. So that's gone out as well. You can't give a 42-page set of terms and conditions, and you can't collect data for you know, because you might want it in the future. That's no longer allowed. The next principle is that if you collect data on people, there's an onus on you to make sure that the data is accurate. So you have to give people a way to update their data and to keep it correct. The next requirement isn't really a new one, and that is that you have to keep the data in a secure manner. And then the last one is the processing. You have to make sure that you're processing the data in a lawful way. So you're not using it for things that you didn't agree that you would use it for when you collected it for in the first place. So when we looked at the overall regulations, and you know, and there's quite a lot of them, we want to look at that in the context of letting agencies. So there's 6 key legal bases for processing, and when we looked at those, we look at estate agencies in a and we've done this for quite a while, so we're not copying their 6 legal bases, but we always look at a letting agency or an estate agency business in from 6 perspectives. You advertise a property, it goes through a viewings and an offers process. There's a move-in process, in-life property management, which of course isn't appropriate necessarily for sales, and then there's a move-out process, which is definitely appropriate for sales. And then on you go again. So the property goes through this cycle, and we looked at each of the business processes and the data flows in there, and we compare that to the data protection regulations, these new regulations, and we've come up with our product design to address those. So first of all, the 6 legal bases, I'm not going to go through them all because they're pretty boring, but the 2 that are important to us is number 1, consent, that you get consent to collect the data. For example, when you advertise a property for viewing, that when the person requests a viewing, that you're explicitly getting them to consent to share their personal data with you for the purposes of viewings. And then the next one that's important to us is contract. So at the contract stage, you're allowed hold and process the data for the person who's gone forward for contract. So in the lettings business, that's at the lease stage, and in the sales business, that's at the sale agreed stage. So for advertising and viewing, your legal basis for processing is getting explicit consent. So actually will sign up to a set of terms and conditions that says the letting agent, will use the data you receive explicitly for the purposes of setting up viewings, comparing people, identifying who's most appropriate for the property, and then setting up viewings and managing the offers process. So you have to get them to explicitly consent to that. And then secondly, when you move from the offer to signing a lease or signing sale agreed, the legal basis for processing there is contract. And at that point in time, you're allowed to have full access to that data because they're signing a contract with you. The next key section that we looked at when we reviewed the regulations was the keeping records. So all controllers must keep records. Now, this isn't as difficult as it sounds. It sounds like there's a huge new set of requirements on the people here, but you really just need to sit down, and you know this in your own mind. This doesn't need to be a massive document written by KPMG. This can be something that you quickly type up yourself. So you identify what data you're processing within your business. So in a letting agency business, for the advertising and viewings and offers, you're asking people potentially, or if you're using our system, you're asking them to view some personal information so you can compare them for the property. So you just note down what that personal information is. And if you use our system, we do this for you, so you actually don't need to do it. The next then is you have to categorize the data subjects and the personal data. So whether they're prospective tenants, they're in situ tenants, or they're your staff, you just need to decide define who those different categories are. Then the recipients, if you're passing the information to anybody in the EU or outside the EU, you need to define that in your document. And then you need to define the retention period, so how long you're keeping the data for. And then lastly, in your record, you need to just state how your security works. So if you've implemented firewalls, if you've implemented storage systems or encryption systems, you just need to write that down and define it. So there can be one simple document. As I said, it doesn't need to be a huge set of policies, and there's no requirement for you to log on to the internet and find a policy from some other company. You can write that for yourselves very quickly. And again, if you use our software for the advertising, viewings, and offer stage, we manage that for you. The next piece then is certification and codes of practice. So there are 10 principles here for certification and codes of practice. And so we went to the Property Services Regulatory Authority and the IPIB and the Data Protection Commissioner, because the GDPR regulations recommend that industry bodies or regulators define a code of practice for their practitioners. So we went to these bodies and asked them for their code of practice, and each one of them came back to us and said they haven't got that in place just yet, or words to that effect. So, it's pretty unsatisfactory, really, that the regulation is coming out and the PRSA and the Data Protection Commissioner don't have a clear set of guidelines for the property industry. So in the absence of those clear guidelines, we've looked at the overall intent, which is fair and transparent processing that there's a legitimate interest for the estate agents to have the data they need to manage the properties and manage the tenants, that you're collecting personal data in an appropriate way and storing it in an appropriate way. And again, if you use our system, we manage that for you. That the information, if needed, the personally recognizable bits of that information are removed. Again, that's not appropriate for us, so we don't need to worry about it. That the information and the individual's rights are presented to them. So in GDPR, under the GDPR regulation, individuals have rights to be forgotten or to keep their information accurate or to fully erase their data or indeed to request that data from you. So we'll come to that in a moment. That's the 8 individual rights, but again, they're pretty straightforward to deal with. So we don't need to be too scared of them. Again, the key there, we believe, is actually not having the data on your premise, or at least to the best of your ability, not storing data within your system. And that's one of the key design principles of our service that we'll quickly show you at the end of this presentation. So there are 4 others. So the technical and organizational measures that you've implemented, breach notification. So this is important. If you have a security breach, it's important that the and it's a material breach. So they actually access personal information. You have a new requirement to notify the appropriate authorities and to notify the people who've been affected. So that's a requirement in your business. So again, what we absolutely strongly recommend is you don't hold data in your business, because if you hold it, it puts a responsibility on you. So we strongly recommend don't hold it, guys. Just don't have it in your business. Use a software like ours where we hold and manage the data on your behalf, and you have 24/7 access to it, so that you don't actually have to manage all these new requirements. And then the next piece then is about dispute resolution procedures. So if someone makes a request or there is a dispute, you need to define what your procedure is for managing that. The 8 individual rights are important, but again, we could get into the weeds here too deeply, and that's not what the purpose of this seminar is, or this webinar is. It's just to inform what those rights are and to show you guys how you can essentially outsource a lot of this compliance requirement to ourselves. But those rights are the right to be informed, so that is as they're signing up or giving you data, that we inform them why that data is being collected and what exactly it's being used for. Right 2 is the right to access, so they can ask you at any point in time, and they've got the right to get a response from you for what data you hold on them. And that's both customers, potential customers, and staff, so it's worth bearing that in mind. The right to rectification, which is they've the right to fix something. So if they've updated their mobile number or their email address changes, they've got the right to tell you must update that on your system. And you need to be able to show that you've done that. So again, that could be quite onerous if you have a lot of data in your system or it's spread across lots of different systems. And again, that's something you'd probably like to outsource to a company like ourselves that does that for a living. The right to erasure or the right to be forgotten is personal right number 4. Again, you know yourself, when information comes into your business, it can come in, it'll be on your email server, it could be on a PC, it could be on a mobile phone, it could be copied into your CRM, it could be in any number of reports that you've sent out. And the law states that if someone says they want to be forgotten by your business, you have to go into each of those systems and delete the data. So again, we come back to the point of saying, look, just don't hold the data in the first place. Don't allow it to come into your business. Use a system like ours where you can view the data for a specific period of time, but you actually don't have it in your business, so that you don't have the overhead of managing all these risks and just managing all this cost associated with this. The right to restrict processing. So if they give you the information and they say, yeah, I want I'm happy for you to allow you to use that for viewings and offers and sending me new offers in the future, they may decide to change their mind, and they've got the right to change their mind, and you have to be able to update your systems. Again, That can be quite onerous for a business, so outsource it. The right to data portability. So if they've set up a profile in your system, they now have the right to transfer it to a competing estate agency down the road. So you need to be aware of that, and you need to be able to facilitate that. They have the right to object to how you're using the data. Even if they have signed up in the first place, they can object, and you have to acknowledge that and manage that. And then rights in relation to automated decision making. So I get most of us aren't doing this. Maybe there's some agencies who are, but we're certainly not, which is using algorithms to make decisions about how people are working. So, you know, we're not doing that. Hopefully you guys aren't either, because that's a whole other set of requirements, and it's quite significant. So, as I mentioned, we asked the Data Protection Commissioner for their guidelines. We got an automated response. We went to the Property Service Regulatory Authority. They said that they don't have a set of guidelines at this point in time, and they directed us to the Data Protection Commissioner. We did go to the Data Protection Commissioner's website and asked them for their or found their program working. They've laid it out quite nicely, but it's not specific enough. You know, I don't know if you guys are the same as me, but I love to be able to just get a sheet in front of me and just tick off that, right, there's 15 things I have to do. Let's knock off those 15 things. And for me, this is way too high level. I can't understand actually what it is I'm supposed to do when I'm sitting in my business from this. It's a great piece of direction, but it's just too generic. I feel we need something that's specific to the property industry, and that's what we've attempted to do here. So now I please want everyone to note, and really want to clearly say, look, we're not legal professionals, and we're not setting ourselves up as data security experts. But what we have done is try to help our customers to comply with this new piece of regulation. And we tried to break it down into as simple as stages as we can. So what we've done is we've broken out the system. And first of all, you create a list of, as I described earlier, of the data you're using in your business and what you're using it for. So you might write down, or we ask people for their first name and their last name, their email address, their home address, whatever it is you ask for. You just need to write that out. And literally writing it out is good enough, or typing it into Word, anything like that's good enough. And then you write out whom you're asking that from. So it could be from your staff, your customers, your prospective customers, landlords, tenants. So you just write it out, and then you write out how long you're going to hold that for, where you hold it. So I hold it in my email system, which is secure by a password, and it's you know, in the Microsoft cloud, for example. There'll be an onus on you then to prove that that information then is stored in Europe, because Microsoft or Google could be storing that in the US, and that would break regulations. But just first of all for yourself. The next thing then is to, we strongly recommend this. This is not in the regulations, but just to ease the burden of compliance for yourself, we absolutely strongly recommend that you delete old data that you're not using, because all that we all have thought in the past, I'll just keep it. You never know what it'll be useful for. But the reality is now that that's a cost for you. Keeping that data, someone's going to say, can you send me all the data you have on me? And if you don't comply with that, you're going to get an audit. Absolutely, as sure as eggs is eggs, you're going to get audited, and then you're going to be in a sorry position. So my strong recommendation to everyone, and this is a personal recommendation, it's not legal advice or detailed technical advice, but I strongly recommend delete your old data, or anything you know is out of date. Just get rid of it out of your business. The next thing then, as new data comes into your business, just make sure that you've got consent for the data that's coming in, the new data that's coming in. And get rid of any old paper stuff that you have. Just get rid. Keep everything in the cloud in Europe, ideally, preferably in Ireland. We can do that for you if you want, so just let us know. The next thing, once you have consent, is to save it. So when someone ticks something on your website to say, yes, I approve you use my data for X, Y, and Z, make sure that that's saved somewhere, because you may be, if you get an audit by the Data Protection Commissioner or potentially in the future by the property regulator, they'll ask you, do you have the consent? And you need to be able to show it. If you can't show it, then you're not compliant. So just showing how you would have collected it isn't good enough. If they say, show me how Jim Urell gave you consent to use that, you need to show literally, there's the printout of where Jim Urell said, I have consent. Go through your systems and remove personal data where you do not have a record of the consent. So as I said, delete the old data, but also delete data where you do not have consent. Now, consent can be an explicit consent or that you've got a contract with this person. If you've got a contract with this person, let's say if it's a lease or a sale agreed document or something like that, then you have consent. Don't worry about it. But if you don't have a legal contract with them and you don't have an explicit document saying where they agreed and gave you consent, then you're in trouble, so delete it. We strongly recommend that you remove all paper from your business that you can, because it's just out of date immediately. As soon as it's signed, it's out of date. There's no way of you keeping that up to date. So, and that's one of the requirements, keeping the personal information up to date. So remove it as much as you can. And again, talk to us. We can do the lease and we'll manage that for you. The next thing then is reviewing contracts with your service providers. So you need to make sure that all contracts you have with service providers are marked as GDPR compliant. Ensure all the data is stored in the EU. So this is going to frighten people a little bit, but if you use an email service from Google, you got to make sure that that email stays in the EU. So you got to ask your service provider, is the data stored in the EU? The next bit then is ensuring you have one of the 6 legal bases. Now, I would definitely boil that down in our business, in the property business, to 2, that there's consent, and before you have a contract and after you have a contract, that you have the contracts in place so you're happy. Stop accepting any new data or applications in for viewing where you don't have consent. Just don't do it anymore, guys. Keep the records. That's not the records of consent. That's records of showing, well, here's what data we're storing, here are the subjects, and here's how we store it. And keep the data secure in the cloud. I would recommend that all of us keep asking the property regulator for the code of practice for our industry, because really there is a requirement for them to tell us how we should operate. And then the last thing I recommend, and this won't surprise you, is that we implement our moving service. If you look across that plan, everything that's starred,
it's 12 hours.
It is something that is solved by our property button service, our moving service. So let me quickly, just to close out the webinar, because I think we're going on half an hour now, so we probably all heard enough about GDPR, show you our new service, which is fully GDPR compliant. So first of all, a tenant, in this case, the tenant's name is Kira. She's viewing properties up on Daft or My Home or on your own website, and she logs her interest as usual, just sends the usual email. She gets a request back from your business. So it says property button on this, but you can imagine that's your estate agency name. And she's asked to create a profile. She logs into the system. Again, it's called Homesy here, but that system has been renamed just to property button. We were told the Homesy name doesn't sound as good as we thought it did. And she explicitly gives consent. See on this piece here, the pink piece. She explicitly gives consent and she explicitly signs up to the terms and conditions. And at this point in time, then she starts creating her profile and adding documents to her profile. She's not sending these to you, but she's given you the right to view them. So you no longer have all the data sitting in your business and all of the requirements that come with that. She can then see all of the properties that she's applied for viewings for, and she can see where she's ranked. Oh, look, I'm ranked number 7 of 58 people here, so there's a chance I'll get a viewing. But for this property down here, there isn't a snowball's chance in hell. I'm 281 out of 382. But for the first time, she's getting transparency. And she knows that she needs to add to her profile, add more information here so that she goes up the ranking here. She's notified then next by SMS that she's been offered a viewing and she's to log in to accept that. She logs in and accepts it. 90 minutes beforehand, she gets a reminder and she has to reconfirm. Next then, after the viewing, you've discussed it with the landlord and the landlord says, yeah, let's offer it to Kira. Kira sent the offer that you verbally agreed with her. She signs the lease electronically, or she can paper sign it, just send a picture of the signature page, and then she signs up for all of the services. She can see her lease at any point in time. She can see the inventory for the property, and she can see all the contracts that she signed. So she's getting a lot of visibility she didn't have before, which is great for Kira. It's also great for you because you don't have any of the compliance requirements now on your business. They're on our business. So how does this work for the letting agent? So on the letting agent side, as the emails come in from Daft or My Home or from your website, the property is automatically added in here. So no new data entry for you guys. The property is just automatically added into the property button portal. And as requests for viewings come in, they just click in. So you see the property there, apartment 1, The Weir. There's 182 people have applied for that over the web. If someone calls into your office and they want to apply just over phone, you can click on plus interest here, and you just add 1 or 2 of their details, and they're sent that request to create a profile that I showed you before. So their information will come in here as well. Above here, there's another property which one of your letting agents has gone through before and is sorted into. There's 3 people I want to call for viewing. The 17 I'll put on standby. I might for this property, I might send them to information about another property if they don't get this one of mine. There's 14 I just don't want here, and they're going to get a no thank you. So you click into the property from, if you click in here, you go in and you see all of the people who've applied for viewings. You see Kira here. You can click on, see her previous landlord reference. You can see her employer reference. They've been validated by her landlord and her employer, so they're not just information Kira's fired in there. You can see her gross salary amount. You can see her preferred move-in date, the rent that she would offer for this. You can view any of the documents that she's uploaded. So you can see, for example, the her bills. You can click on any of the other information and see it here. You can decide to approve her or reject her. You can also decide to create some filters. You might decide, okay, great, Kira's great, but I don't want to look at 182 people. You might decide to filter the 182 by, I only want 5-star profiles, so only 2 come up. You might want to filter it by, I only want people with 100 grand salary. You might decide, oh, well, the rent for this, I need to filter it by here. The landlord here wants 2,200. I'm only going to look at people who can afford that. Or you might decide, oh, I need people to move in next Tuesday, so you might put it in there and decide that. So once you've got that, you've gone from 182 people down to 2 here. You might decide then, yeah, I'm going to shortlist Kira. I really like her, or not. You might put in your own comments because, God forbid, you're sick tomorrow and the landlord calls in. Your colleague wants to be able to see your notes from the call with Kira. So that's basically how it's lovely and simple for you guys to go from 182 emails in your inbox, which have created a load of compliance requirements for you, to 0 compliance requirements, and an ability to objectively compare people based on their affordability and their previous tenancy behavior, which are deemed as non-discriminatory by the Data Protection Commissioner, so fully compliant with what we can do. So how do we get the tenant reference? Because that's a crucial part of their profile here. How do we get that validated? So what we do here is we identify the landlord for that property. Our Kira has told us who the landlord is. We go away and test that, make sure that's correct. We provide a BER service for their property. The landlord then clicks through and approves that Kira got was a tenant there. She paid her rent on time. She got her full deposit back. There's no outstanding cases or bills. That is the reference. And click, they get a BER certificate or BER credit for their property, which they can only use at that property, proving again that they're the landlord for that property. Kira's profile now has increased. Her ability to potentially, her score for that property, she may have gone now from number 2 for that property to number 1 because she's a validated reference. What's been happening now in your system? So you can see again for the advertised properties, what's happening with any of your properties today. You can see the notifications coming up and you can click to take action. You can see what's happening, that Kira's been shortlisted. The viewing appointment was set up, that you liked Kira, that she completed the offer. You can see the move-in information. You can see that the landlord validated the information and that the lease is signed. So you can see exactly what's happening in your business. That's stored in our system. You can import Kira's profile once you get to the contract state. So so you're happy. You've got all the legal bases confirmed for processing, and you've got all the information you need without any of the compliance requirements. If someone decides they want to view this, you can see it now on our website, or contact your account manager, and you can sign up today at that address there. So guys, thank you very much for listening. Really appreciate it. I hope you didn't find it too boring. It's not a great subject, GDPR, but hopefully we simplified it enough for you. We'd be happy to answer any questions, and thank you for your time.